So, dear ladies and gentlemen, participants of the conference, greetings to those who already joined us. Those who are still in the coffee break, please, really want to get you back because we're about to continue a small announcement. We already had requests regarding the stream. So the online stream was cancelled, but we have the video recording, and tomorrow on the official website you will see the link to get the recording. You'll have a chance to watch, to share. Okay, so with your help, I really want to express the gratitude to organizers and partners of the event, Ukrainian NGO called Tribunal, NGO Justice and Accountability for Ukraine, expressing our gratitude to them for this event. And also our applause to strategic partner Toronto Kyiv, and media partner, the legal practice. So, after this small break, I really encourage you all to return, and we will start the second panel. It relates to immunity issue. You, I guess, know that 3 top leaders of any country, President, Prime Minister, and the Minister of Foreign Affairs, have immunity when it comes to any court and jurisdiction when they are in their capacity. But can we actually take these immunities away? Can we cancel those immunities? How can we do it? So the speakers will discuss that, right? So I really want the moderator of this discussion, the Ambassador at Large, MFA of Ukraine, Anton Korynevych, to step on that stage. And of course, you will be joined by our distinguished speakers. So we have Lesia Zaburanna
on the establishment of the special tribunal for the crime of aggression against Ukraine. Your biggest round of applause. Прошу, проходьте, займайте свої місця.
Please take your seats.
Right now, Oleksandr Kachura, Member of Parliament, head of the Inter-factional Association Tribunal for Russian Aggressors, member of the Working Group on the establishment of the Special Tribunal for the Crime of Aggression against Ukraine. Ваші оплески. Also, we will meet at this stage Vitaliy Salikhov, member of the High Council of Justice of Ukraine, and also Ivan Horodyskyy, Vice President of the Ukrainian Bar Association, Director of Dnistrianskyi Center. Але це ще не все.
This is not all, because during this panel discussion, we expect to get our guests joining us online.
Frank Hofmeister, Director for General Affairs and the Chief Legal Officer at European External Association Services and Professor of International Economic Law in the LLM in International and European Law Program of the Brussels School of Governance. We will meet Kerry McDougall, Melbourne Law School, University of Melbourne. Also, we will meet Geoffrey Nice, British barrister, lead prosecutor for the UN in trial of Slobodan Milosevic. We will hear Marie-Hélène Proulx, President, International Criminal Court Bar Association. And last but not least, Max Baryshnikov, partner at BKB Attorneys at Law, co-founder of the initiative group of the Civic Hub, Kick Russia Out of the UN. Thank you very much. Antone?
So, Anton, please, the mic is yours. Thank you so much. Thank you so much, and good afternoon, ladies and gentlemen, dear colleagues. Of course, it's so pleasant, it's so important to get you all here at this conference dedicated to establishment and the need to establish the special tribunal on the crime of aggression against Ukraine, and it's really important for us. we have this wonderful company. We have experts from Ukraine and other countries, experts in law and criminal law, and we definitely, from various perspectives, various standpoints, we can assess why the issue of special tribunal establishment is one of the fundamental to establish the full accountability for all those crimes committed in the territory of Ukraine during the Russian aggression, and that this is a fundamental issue for international law in general, because this crime of aggression, this Russian aggression against Ukraine, I guess it's the biggest wave of aggression since 1945 in Europe. Of course, just leaving it without proper legal assessment, we just can't do it. We can't allow that. And this may damage the international law system, the international order, and it may pose certain damage to the very concept of cooperation of states for combating the crimes. It's important that during the first panel moderated by Mr. Smirnov, you heard various thoughts and opinions on why special tribunal should be established. It must be established. What is the better way to do it? I think that from the first panel discussion, all of those listening to it, we all have to take some important value. The important principles should be taken. Tribunal should be established. That's it, period. Not establishing this kind of entity with jurisdiction for the crime of aggression against Ukraine, we just can't allow that. This will be a damage, a huge damage, not only for our interests, but for the international law and international community in general. So, to me, it seems that for us it's important today during these panel discussions, and we have highly professional people. They will talk about various issues of accountability for the crime of aggression to bring this value with us, that, okay, to take the statement. The question is not if, but how for the special tribunal. The answer, how, we will find it. The second panel discussion, as Miss Host said, it's about personal and functional immunity and the practice of international criminal tribunals, per se. Because truly, the issue of immunity is one of the key, especially when we talk about the crime of aggression. Because when we talk about three other categories of international crimes, genocide, against humanity, and war crimes, we understand, taking the practice of such tribunals, that who can be accused of it? Any individual, basically, any person, any human being. Just an average military or just any person taking part in the military conflict, or like civilian supervisor, or just anyone, representative of the state authorities. So we have some great example of it. So 2 orders, 2 arrest orders given by the ICC. One goes for Putin and the second goes for the Children's Ombudsman of Russia, because they actually allowed the deportation of Ukrainian kids from our state. So the crime of aggression has its peculiarity, and I really know that the speakers will discuss that. The crime of aggression is in the leadership crime, as we say. It means that for the crime of aggression, the international law does not stipulate the accountability for some average military. For soldiers, lieutenants are not held accountable officers, but who is held accountable? Those who have these functions, those whose mandate, those whose capacity makes it possible for them to give orders to start, to continue the hostile activities. So when we talk about the crime of aggression, we speak of the responsibility of representatives of political and military leadership, because it's them who can give orders to continue this war. This is a leadership crime, so we speak about personal and functional immunities for the political and military leadership. International law stipulates 2 categories of immunities: functional or immunities Ratione materia. These actually are defined by the capacity and the position and rank of the person. Being in certain capacity, the person may make decisions. Functional immunities, these are given to so many officials of the state, like this can be a Minister of Defense or the commander of certain type of units, so the National Guard commander. So certain people who are in the capacity to give orders for aggressive war. And we have a special category, already mentioned, representatives of so-called the triplet. So the head of MFA, prime minister, and the president. Those who have personal immunities ex officio, so they have immunity just because they can represent their states in international relations without any additional mandates, instructions, or guidelines. So now, during this panel, we will discuss how should we establish the tribunal, what are the key principles should be put in these fundamental documents for the tribunal to be for it to handle the personal and functional immunities, including this triplet. And it's so good that we have this wonderful company and team of speakers representing Ukrainian politicians and also our European colleagues, and the academia representatives of universities from our key jurisdictions. For the start of the discussion, we'll also use English and Ukrainian. I think this is really something we'll have at all discussions. We'll listen to our Ukrainian speakers and the foreign ones as well. Who will start the panel discussion? I invite Oleksandr Kachura to be the first one, the MP of Ukrainian Parliament, head of Inter-factional Association Tribunal for Russian Aggressors. So just characterize why for Ukrainian MPs it's really so important the issue of special tribunal establishment, which could tackle these immunities, and why MPs, national MPs, are working for that together with the team of the president, with the government, with the public. So greetings to everyone. Truly, I was thinking that the architecture of security, and those standards that we had before the full-scale invasion, this is the first precedent after the WW2, like the full-scale invasion. For the first time it happened. These changed, and we have now to take non-standard approaches for us to tackle that we have. Andriy Smirnov, when he mentioned at the beginning of the full-scale invasion, if the tribunal is established, we can say it now. I guess Maria Mezintseva and Homenko, they know how it was because they lead the international track and help us in diplomatic dimension. They help to push that. People had smiles on their faces, when they talked to us, like, what the hell is tribunal? You have just to survive for a couple of days. Just stop talking about it. And right now, we talk of details. We understand the tribunal itself, per se, will be established. That the ICC warrants are there, but one of our foreign experts said that, okay, you have the warrant. What do you want? Like, what kind of tribunal do you want? Okay, so we can see that today some weird processes are happening in the Southern African Republic, Putin's taking part in BRICS. Okay, let's take this. Let's consider this. This is a big challenge we'll have to tackle. Our diplomacy will tackle it. ICC does not consider the case before the accused person gets to the courtroom itself. So we have to understand that we have this triplet, as they say, yeah? We have Mr. Lavrov, who is, let's say, the Ribbentrop, Hitler's Ribbentrop. He is performing the same functions, but there's no warrant for him. And he can actually get rid of the accountability, and he can evade it. And only the International Tribunal. Anton will tell about these approaches, and there are some ideas. As a lawyer, I think that International Tribunal is just throwing away all those immunities, all possible immunities. Yes, we have some functional immunity and personal. And today Andriy Smirnov, well, he gave a very interesting statement that functional immunity does not is not applicable in this case because you will not see in any documents, you know, in the constitution of the state, he mentioned African countries, you will never see the capacity to initiate aggression against the sovereign state. It's not there. Not in a single document. Personal immunity, yes. Personal immunity is, I would say, it's a fundamental issue for some discussions.
And today we heard a point that internationalized tribunal, even if it will have a supreme jurisdiction, even if it will get the support from General Assembly, whether it will be enough to lift the personal immunity from these three high individuals, high officials, I believe that the only immunity that the international community should have is the immunity to double standards and the willingness to negotiate with those who committed aggression. This is the only immunity that should exist after our victory, after the establishment of a special tribunal. That should be the only immunity for all those dictators that are looking at us very carefully. Because that's not only our matter, because when you know people who lost their children in this war, surely you will take the side of the establishment of the tribunal. There's no alternative to that matter, but this is a matter for the whole world to regulate. All the dictators are looking carefully at the events in Ukraine, so should we not establish the tribunal, those dictators will try to commit their own crime. So, tribunal means victory. Thank you, Alexander. Indeed, it is important that the MPs are actively working on the matter, including in cooperation with our partners, because it's important to have one voice of the Ukrainian society and all the branches of power, including the society expert environment. It's important to spread the message, and I believe this conference is doing that the tribunal and the court process for the crime of aggression, this is something that the whole Ukrainian society needs at different levels. It's important for all the experts, for all the public officials. And Alexander also gave us a very important message that if this time, and this was also mentioned by our colleagues at the first panel, if the crime of aggression, if this violation of the fundamental principle of the international law, the principle of not using the force, if that principle if this violation will be left unanswered, it will create a lot of challenges for the international community.
Maybe to the discussion on more the legal issues, on the legal side, to our friend and colleague, Dr. Frank Hofmeister, head of legal in the European External Action Service. Here, I need to mention that we have a great level of cooperation with our colleagues from EAS and from the whole European Union, and we are grateful for the support which we get from them, in particular within the resolutions which are supported and adopted by the European Parliament, on the level also of the European Council conclusions. 5 of them already talk on the necessity to ensure accountability for the crime of aggression, and also our colleagues from European External Action Service are taking active part in our discussions within the core group. Dear Frank, if I may pass the floor to you and ask you, what's your position as a legal scholar and legal practitioner on the issue of the personal and functional immunities in the practice of international criminal tribunals, and how to deal with this issue in relation to the crime of aggression against Ukraine?
Personal capacity, but as you just mentioned, dear Anton, Ambassador Korynevych, I'm a legal advisor for the EU High Representative, and we very closely follow the discussions within the European Union, but also in the core group together with my esteemed colleagues from the European Commission. And by the way, to return the compliment, Anton is a very apt chairman of this core group and drives the process with remarkable ease. So, the European Union is indeed fully behind the principle to establish full accountability for the crime of aggression. And that is also why we have just recently founded the International Center for the Prosecution of the Crime of Aggression in The Hague, and it is starting working these days. But my topic is here immunities, and as explained by Anton, we need to distinguish between the functional immunities, which high state officials may try to plead to say, but I acted on behalf of my state, so I should not be personally held accountable, and the personal immunity, which is a very specific topic for the Troika, the top three. So let's first look at functional immunity, and here there is a draft project of the UN International Law Commission, and the project was saying that, well, in principle, state officials do have functional immunity, but there are certain exceptions. And the exceptions relate to the most serious crimes. However, when the ILC debated that in 2017, there was no consensus about the question, does the exception also apply to the crime of aggression? And in the report of the ILC, we can see some hesitation. The ILC said, yeah, but the crime of aggression is not yet activated by the ICC, it's highly political, and it is prone to abuse. That is why there was a certain tendency not to include the crime of aggression in the exceptions. However, in the European Union, we have discussed that, also in the core group, and there is a predominant view that those reasons are not pertinent in this case. Number one, the crime of aggression has been activated in the meantime. Number two, the political character does not really stand against. And number three, most importantly, the UN General Assembly, with over 140 votes, has determined that there was an act of aggression. So there is no risk of abuse. And that brings me to my first conclusion. It's a very important one. All EU member states agree that in this case, functional impunity will not apply. So all those Russian leaders, be them military, be them political, cannot plead functional immunity before a special tribunal. I think it's a major finding which should not be underestimated. Turning now to personal immunity, and there the situation becomes a bit more complicated because we have to look at international jurisprudence, and the case law is always very much related to the facts of each case. So the first case I would like to mention is the International Court of Justice arrest warrant case. And there the highest UN court said, well, under international law, there is personal immunity of the big three. However, there may be exceptions, and I quote, before certain international criminal courts where they have jurisdiction. And the ICC at the time, it was explicitly the International Criminal Court for Yugoslavia, Rwanda, and the ICC. Now, since I'm asked to talk as a lawyer, I need to qualify that. So what are those three international tribunals? Yugoslavia and Rwanda were established by a resolution of the UN Security Council under Chapter 7, and the ICC is established by a multilateral treaty by over 120 states. So that's important, that the mode of those tribunals is different to the mode we are currently discussing. Second, there is a very famous judgment of the al-Bashir case before the International Criminal Court, and it was about the question of non-cooperation of an ICC member to extradite a head state, in this case Sudan. And there the ICC found that there is no rule of customary international law recognizing head of state immunity before international courts in the exercise of jurisdiction. Well, here that case was in the context of the ICC, and that also explains, as Anton just mentioned, that currently President Putin is indicted under an arrest warrant. This is ICC related. And then we have a third case, that is the Sierra Leone judgment on Charles Taylor. And here the court said, I think I'm an international tribunal, and on that basis I cannot accept the immunity of Mr. Taylor. Again, on the details, it's important to know that the Sierra Leone tribunal was established by the UN and Sierra Leone together, but on the side of the UN, it was only done after a clear express go-ahead of the Security Council, and that was also mentioned in the judgment. So another case of an international tribunal with Security Council involvement. So when I sum up these three cases, you will see none of case directly fits into the question of who is acting around. Because the question raised in the first panel, is it sufficient if you have the...
Unfortunately, the internet connection of the speaker is very poor. The interpreter will continue when the connection will be reestablished.
Yeah. Frank, you're with us, though the connection doesn't look to be very stable, but we listen very carefully to what you say, and actually we are taking notes, so please go ahead.
Good, thank you, Anton. I'm sorry for the technical hiccup, but I'm in a stable connection in the ES, so I don't know where precisely the problem comes from. So I was trying to sum up the case law, and so the question is, what does it tell us for the situation at hand? Would it apply to a UN General Assembly-based tribunal or not? Would the UN General Assembly be regarded as having sufficient power to overcome the personal immunity? And on that one, I have to be correct with you. This is controversial. Some states say yes, other states say no. It is a controversial topic, and therefore we need to work on the assumption that, well, there is a certain doubt whether the jurisprudence on international tribunals can simply be transferred to a UN General Assembly-based solution. But having said this, I don't think that's a major drawback, because, and here I repeat, number one, any future tribunal, irrespective of modalities, could initiate proceedings against Russian high officials. They cannot plead functional immunity. Second, there is personal immunity of the Troika while being in office, and it's controversial whether it can be lifted by a UN General Assembly-based tribunal. But in any case, personal immunity ceases to exist once a Troika member has left office. And that's also very important to understand. So if the president or the foreign minister is not in office anymore, the personal immunity cannot protect him. And therefore, the issue is not decisive for the format for the time being, and the core group can try to continue the work on the matter and find the most appropriate solution on the model, including the ones which were discussed in panel 1. And I would like to echo what the legal advisor of the Council of Europe, Jörg Vitaliy, has said. There may be models of a very strongly internationalized tribunal, and there may be models with Ukraine at the root of the jurisdiction conferring and delegating its powers, which should be explored, and that would be then simply be analyzed in light of the case law I have just described. Thank you very much for your attention, and let me underline again, the European Union as a whole will do its best to fully support the establishment of a tribunal to ensure full accountability for the profession. Thank you very much.
Thank you so much, dear Frank, for your valuable thoughts and valuable contribution. And of course, this EU solidarity with Ukraine and the EU support on the road of establishment of a tribunal is of crucial importance for us because we feel that whenever we have international partners and friends working together with us on this matter, so of course we will surely succeed in this goal, though this is not an easy job, and this is also understood. Of course, the establishment of the International Center for the Prosecution of the Crime of Aggression against Ukraine in The Hague was underlined by Mr. Prime Minister Denis Shmyhal, by Mr. Andriy Smirnov, by other panelists during the first panel discussion, and of course it is of crucial importance for us, as well as other EU support to this matter, in particular the European Council conclusions, the European Parliament's resolutions, and all the other instruments. So, dear Frank, thank you so much for your kind words. We will continue our work to get the job done. Шановні колеги, я думаю, що
Dear colleagues, I believe Mr. Hofmeister has told us very important things, that the European Union supports the establishment of the Tribunal on the crime of aggression against Ukraine. This is reflected in the opinions of the European Council and the resolution of the European Parliament, and it's also reflected with the idea of the establishment of the criminal prosecution for the crime of aggression in Hague, and this is already an investigation. So we as lawyers, politicians and the experts, we understand that the investigation shall always lead in the court hearing, and Mr. Hofmeister has also mentioned that as of today all the EU member nations agree that at least functional immunity shall not be applied. That's shall not be applied to any tribunal of any model. I think this is already an important interim result, and as Mr. Hofmeister has already mentioned, we shall continue working in order to find a legal response to all the key legal matters, and surely Ukrainian diplomacy will also be working on the draft resolution of the immunities that Mr. Hofmeister has already mentioned. I would like to pass the floor to Lesia Zaburanna, a Member of Parliament, member of the Working Group on the Establishment of Special Tribunal on the Crime of Aggression against Ukraine. So Lesia is working very hard in order to promote this idea. So Lesia, could you share with us your thoughts? Why is that important? If you can have any feedback from the international partners on that matter, and what's your future plans together with your colleagues in MP, how you're planning to work on that matter in the Parliament? Well, first of all, I'd like to say that it's great that we'll have some foreign experts, and surely there will be a possibility to listen to the recorded option of this conference, and it's great that we are engaging our partners in restoring the accountability. I can see a lot of young faces are interested in this matter, and indeed we're doing all of that, and surely the world will do that for you, because you have to understand, and everyone has to understand, that justice is the supreme law, is the supreme benefit of any civilized development model. We can have many conversations on different tragic stories, on all the cases we had in Ukraine. Just recently we've had a tragedy in Chernihiv, but still every Ukrainian, every citizen of the world understands that bringing to accountability is something that we have to offer to all the war criminals, but the chief perpetrators in this horrible act, whose thoughts are hard to be analyzed. These are the leaders, the political and military leaders of Russia.
And for them, for them, like all the mothers, all daughters, and sons, and husbands, all Ukrainians. And they want to get justice because of these people. They want these to be punished. And our friends in all countries fully recognize this. They understand that, and they bring that message. So, Anton asked a very good question. Why it's important to have this parliamentary track? What do we do for it? And how it actually affects the successful promotion and progress of the special tribunal establishment. Our key task is, well, if we want to get, as a result, I'm pretty sure that this will happen, and that this will actually even soon get the verdict for these people, or I can't even call them people, because of what they commit in Ukraine. It's important for this verdict to be internationally recognized, for this to be legitimate. So, for that, we need the whole international community to join, as many of them can, to join this single concept, single idea of establishment of the International Tribunal. So, it's so important to work at all levels, to work with the citizens of all the countries, parliamentaries, bringing the necessary signal to the governments, to leaders of countries, working with the leaders, with those who have the capacity to sign, to recognize all that organizational framework for the special tribunal establishment. We heard the proper statement, that definitely a year and a half ago, when for the first time we started speaking of that issue together with the government, with the ministry, with the office of president, at Parliamentary Assembly of the Council of Europe, it was mentioned, the International Tribunal term was implemented in one of the resolutions. It seemed like a science fiction, but now we have a huge amount of resolutions of national parliaments, those supporting and those stating that it is definitely necessary to establish a tribunal. Take into consideration the Ukrainian vision of it. Of course, with all the immunities taken away from the top leaders of Russia. So, what is really important and what was our job related with? We cooperate a lot. We actively cooperate with parliaments in various countries, and we mentioned the US. We have countries which substantially impact the opinions of others. If we talk about the US, the United States of America, of course, are the flagship when it comes to, they form the opinion of the global South countries. So for us it's important for the idea of tribunal and the modality to be recognized by as many countries as we can. Only then we will get the result and the effect we definitely want to get. When together with colleagues we started working with the US, namely with United Kingdom, I'll be frank, not always it was so simple, because due to some certain history, some experience, convincing them to establish a tribunal for the crime of aggression, it seemed to be so hard, but what the result we have today. As of now, in the United States and Congress, we already have the Committee of Foreign Affairs actually supported the resolution on tribunal establishment and lifting the immunity. So, what Ukraine is actually trying to achieve, what was supported by Democrats and Republicans, the majority. So, we have the same resolution in Senate. What does it give? Cumulatively, it gives the push, the impetus for the final decision-making at the level of the president to support this institution, to support the tribunal idea. And I'm pretty sure, and I want to assure you, that the support of United States and other countries will impact positively other states as well, like the global South. But this is not something we'll stop at. We actively cooperate with our European colleagues, and we work with the United Kingdom. Every day, we try to convince them, as I told you, at all levels, that there is a huge need to get this tool, specifically this tool to restore justice, which will definitely be a unique one in the history of mankind. So, to show that the whole civilized democratic world has a single vision to ensure that crime of aggression is avoided. And definitely a huge argument, let's say, and a substantial argument, substantial role for us, what that is. One of the consequences becomes that the kids, they suffer from it. Today we have almost 500 kids who already died because of crimes committed by Russia. Almost 20,000 of officially deported children, just officially. What we mentioned is it's the act of genocide, in fact. And the civilized country, other civilized country, cannot be flexible about it. You know, we all understand that younger generations, kids, this is the future of the nation, the future of the civilized world. And we have to stop that altogether. So, I'm so happy and I'm so pleased that we have very productive combination of our efforts at the level of parliament, at the level of governments, at the level of the office of president, and that we actively promote this idea. And I'm absolutely convinced that this idea will definitely be implemented. And this will become another historical landmark, you know. So, thank you. Thank you so much, Lesia. Definitely, after Alexander's and Lesia's speeches and other MPs we have in the hall, so we'd like to express gratitude for your work, and please do continue moving forward. Do not stop, do not slow down. So, we have the resolution of the national parliaments supporting 7 resolutions of the Parliamentary Assembly. We have 9, they say. Okay, thank you, Maria. Thank you so much. You're very attentive to it. Okay, so 3 resolutions of the Parliamentary Assembly of NATO, 2 resolutions of OSCE Parliamentary Assembly, and we do hope that this, and we are sure this political support will be really important for us to get the victory, to achieve the goal. On the legal track, on the accountability track, Lesia also mentioned, she mentioned those horrible atrocities, those crimes committed by the citizens of Russia, and they have to be held accountable for these crimes. In particular, the war crime in Chernihiv, this cannot be, we can't find any excuse for it. We can't even speculate about it. It's a war crime, no doubt. So we have to stress on the idea that any war crime, any crime against humanity, it's the hardest international crime, but it's just an episode. The crime of aggression gives us a chance to hold Russia accountable in this, and to ensure that we have full justice. So that's why we are moving forward on the track.
Give to our big friend and colleague, Professor Kerry McDougall from Melbourne School of Law, from Melbourne University. And though Australia lies quite far away from Ukraine in terms of geography and in terms of time zones, Kerry assists us a lot in providing advice and support to our efforts in establishing the special tribunal. So we are very grateful to her efforts in this relation, and do really appreciate her support and help to us. And also Kerry is one of the leading world international academics in the sphere of crime of aggression research. She's the author of one of the best international treatise textbooks on the crime of aggression, and it's a pleasure that leading international academics and world experts support Ukraine on our efforts, on our path towards justice, in particular in relation to the crime of aggression. So, dear Kerry, if I may kindly drop you a question from my side, maybe to talk in the same legal manner as Frank did on the issue of personal and functional immunities. What are your thoughts in relation to these two categories of immunities in relation to the crime of aggression against Ukraine, and how we can override them? What shall we do to not have such an issue?
Well, thank you, my dear friend Anton, for those very kind words of introduction. I would very much like to thank the organisers of the conference for an invitation to join you today. I'm sorry I can't be in Kiev. I certainly would like to record my support for the people of Ukraine and my very deep admiration for Ukraine's commitment to international law and its efforts to hold those most responsible for the crimes of aggression committed against it to account. And it has been my absolute honour to work alongside Anton and other Ukrainian colleagues to try and make that a reality. So Professor Hofmeister has very helpfully painted a picture of the operation of personal and functional immunity. Respectfully, I have to disagree with him, however, in a couple of key respects. So I think one point we do agree on is that personal immunity enjoyed by head of state, head of government, foreign minister would prevent the prosecution of those individuals before domestic, or I would say internationalized or hybrid tribunal that is part of Ukraine or any other state's domestic legal system during their term in office. And I think we need to recognize that one very important consequence of this is not just that those individuals couldn't be arrested and prosecuted, but that a tribunal couldn't even issue an arrest warrant against them. And I think that would significantly detract from the expressive value of the tribunal, its ability to deter future aggression or further aggression against Ukraine, and to isolate individuals like Putin. Professor Hofmeister suggested that this issue is not decisive, personal immunity, because it ceases once those individuals leave office. And here I think we need to be very careful to pay attention to the detail of the ICJ's jurisprudence in the arrest warrants case. Because the court said once leaving office, the Troika can be prosecuted for acts committed prior or subsequent to their term of office, i.e. not really what we're talking about here in the case of crimes of aggression committed against Ukraine. And they can be committed for acts committed in a private capacity during their term in office. And I think it's pretty difficult to argue that a use of force by a person in a position effectively to exercise control over or to direct the political or military action of a state is not an official act. So that brings us squarely to the issue of functional immunity. Now, it's absolutely wonderful that the European Union's members have expressed the view that they disagree with the International Law Commission's position that functional immunity continues to apply to the crime of aggression. The International Law Commission has invited comments on its draft articles on immunities of state officials from foreign criminal jurisdiction. And so there is a window currently open for states to express views on those draft articles and to tell the ILC that they think immunity should be equally inapplicable to a prosecution before a domestic court for the crime of aggression. But as wonderful as the developments on the European Union member side is, they don't represent all UN member states. States, I think, are clearly divided on this issue. At least that was my impression during my time as a legal advisor serving in the United Nations General Assembly's Sixth Committee. And so I think there is an outstanding risk that before any domestic court, before an internationalised tribunal that is part of Ukraine's domestic legal system or another state's legal system that judges could find that functional immunity continues to apply as a matter of customary international law, and effectively that would mean that no one could be prosecuted for the crimes of aggression that have been committed against Ukraine. So that's a residual risk that is carried by the internationalised model. Compare this to the position for an international tribunal. There's now a fairly well-established line of jurisprudence holding that immunities, neither personal immunity nor functional immunity, applies to a criminal prosecution before an international tribunal. Professor Hofmeister mentioned some but not all of the relevant developments. These start really with Principle 3 in the Nuremberg Principles adopted shortly after the founding of the UN. Importantly, we have jurisprudence from the ICTY and the ICTR. Now, of course, the provisions in the ICTY and ICTR statutes that made immunities inapplicable were adopted by the Security Council, and under Chapter 7, obviously the Security Council has the power to dispense with immunities. But the ICTY in the Franzia case and in an interlocutory decision in the Milosevic case held that those provisions of the ICTY and ICTR statutes reflected existing customary international law. Professor Hofmeister has already made mention of the ICJ decision in the arrest warrants case, the Special Court of Sierra Leone's decision in the Taylor case, and the ICC Appeals Chamber's decision in the al-Bashir and Jordan case. It is important to acknowledge that a number of states and commentators have expressed disagreement with the conclusions reached in those cases, but there is now, I think, a really clear line of jurisprudence that has been echoed over and over again by international courts and tribunals. And so while this is ultimately a question that would have to be resolved by the judges of a special tribunal, I think it's quite difficult to see a judicial bench departing from this line of authority. So you have real uncertainty about the status of immunities before an internationalised tribunal. I think a fairly compelling argument can be made that immunities would not apply before an international tribunal. The million-dollar question then is, what is an international tribunal? Professor Hofmeister has told us that the ICJ didn't define an international tribunal in the arrest warrants case, but it did list the ICTY, ICTR, and ICC as illustrative examples. And I think what's really important to note in this context is Professor Hofmeister, suggested that the ICC qualified because it has more than 120 states parties. But at the time the arrest warrants decision was handed down, the Rome Statute had actually only been ratified by 52 states. So importantly, the arrest warrants decision tells us both that an international tribunal does not have to be established by the Security Council, nor does it need to have near universal support. The most detailed case law we have on the qualities of a qualifying international tribunal is in the Special Court of Sierra Leone Taylor case. Professor Hofmeister mentioned that the court was established by an agreement concluded between the UN and Sierra Leone that was negotiated by the UN Secretary General at the request of the Security Council. Now, quite critically, the Security Council did not rely on its Chapter 7 powers in requesting the SG to engage in those negotiations. And while the Special Court for Sierra Leone emphasised that the Council had the power under the Charter, UN Charter, to initiate the establishment of an agreement, and that the resulting agreement was made on behalf of all UN member states and was therefore an expression of the will of the international community, despite what is sometimes claimed in the literature, there's nothing in the Taylor case that suggests that the Council's role was determinative. If you read the case decision closely, what the court said was that the inescapable conclusion that it was an international criminal court before which immunities didn't apply were based on indicia too numerous to enumerate in its constitutive instruments. and highlighted as being of special relevance was the fact that the court was not part of the judiciary of Sierra Leone and was not a national court, that it was an international organisation with international legal capacity and autonomous will, and that the immunity provisions in its statute were broadly similar to those found in the statutes of the Yugoslav Rwandan tribunals and the ICC. And so on that basis, I would argue there's a very strong argument that immunities would not apply before an international tribunal established by an agreement concluded between the United Nations and Ukraine at the request of the UN General Assembly. And for what it's worth, I also think that you can argue that immunities would be inapplicable before a tribunal established by treaty. And of course, the broader, more diverse the treaty's membership is, the stronger the argument would be that the tribunal could properly be classified as an international one before which immunities don't apply. Thanks very much, Anton.
Thank you very much, dear Kerry, for this wonderful presentation, for your ideas, your advice and your support, which again we feel every time when we work on this issue, and it's pretty much every day without any breaks throughout this year and a half. It's really important to have this discussion during, in particular, our panelists. We may have different views, and it's okay. That's why it is important for us to have the common ground and to find this common ground on which we may build the way forward. And I think that it is really great that today we feel during this discussion that at least on the issue of the functional immunities, we are on the same page, in particular when we talk about Ukraine's position that functional immunities shall not apply before any kind of a tribunal established. And to hear that we have this position also from all the EU member states is, of course, something which we do appreciate and will move forward, in particular in relation to the personal immunities of so-called Troika. And of course, Ukraine will pay particular attention to the issue of draft articles on immunities of state officials from foreign criminal jurisdiction and draft Article 7, which we believe since 2014 a lot of things have happened, and that draft article should not look as it looks now, and we think that it's a quite obvious thing. So Ukraine will, of course, present its comments and observations. Шановні колеги, я думаю, що...
Dear colleagues, I believe after the first panel discussion and the part of the second panel discussion, we need to have a separate discussion on an aspect which is very evident for the international lawyers, but still it's important to discuss that for a wider audience. As you can see, we have leading lawyers, practitioners, experts, scientists, members of academia from different countries, and they're supporting us on the way to the establishment of the Special Tribunal on the crime of aggression. We also have some of the key legal advisors of the Council of Europe and the European Union. So it's important that our objective, whenever we're talking about the establishment of a special tribunal, is the aim to establish a body with the jurisdiction of the court body on a single crime, the crime of aggression against Ukraine. That is very clear. With respect to the situation of Russia against our country, we are not aiming to create a tribunal that could be applied for all the crimes of aggression, because in the ideal world that should be done by ICC. We're not planning to weaken the ICC or to create any alternative mechanisms. Today we are saying that in order to achieve a comprehensive responsibility, it's not enough for us to talk only for the accountability for war crimes, crimes against humanity and the crime of genocide, which is currently effectively covered by the ICC. For this, full responsibility will need to have a mechanism that could be applied to the crime of aggression against Ukraine. So once again, the official position of all those dealing with this issue, we want the establishment of a tribunal that would be supplementary mechanism to the mechanism of the ICC with the jurisdiction to cover the crime which ICC cannot be considering due to the lack of the jurisdiction in the nearest perspective, and not only in the nearest perspective. So we're not changing what is currently working today. Instead, we're trying to establish the mechanisms that would cover the loopholes available. Now I'd like to pass the floor to Vitaliy Salikhov, the member of the High Council of Justice of Ukraine. So why is that for for Ukrainian lawyers? Why is that for members of the High Council of Justice, for judges, for the lawyers, for prosecutors, for all the participants of law, so to say? Why is the issue of accountability of Russian citizens for international crime is important? Why is it important to have responsibility for the crime of aggression? First, we have to extend words of gratitude for the organizers of this event. It is truly a very important one for Ukraine, as it would identify the possible mechanisms for drawing to accountability, for holding to accountability all those responsible for committing the crime of aggression. I'd like to extend words of gratitude to the audience. It's great that we've gathered today so many people that do care about the challenge we face, talking about the particularities of the court hearing of those cases. We have to understand that the majority of the cases shall be considered in the courts of general jurisdiction and in our courts. And we have mentioned that, and the leadership of our country has mentioned that the demand for justice is enormous during the times of war. We clearly understand this, but still, an important demand by any citizen of my country is to develop the ways for holding accountable these three key officials of Russia who prepared this act of aggression. So it's important, really, to hold those perpetrators to accountability. The only way this is possible under current conditions, and this is something we clearly understand, that is the establishment of an international special tribunal. Otherwise, overcoming the functional and personal immunity is something that we couldn't do. I might disagree with some of the points of my counterparts in terms of the fact that we've overcome the issue of a functional immunity, saying that it shall not apply to this case, but there are questions and challenges with regards to the personal immunity. I believe overcoming personal immunity is something that is already mentioned in the previous cases of the ICC, and it has already been mentioned that in certain cases the three key officials of the aggressor state might be holding or accountable. As for the functional immunity, I believe this is not something that is mentioned in the case law. So if our colleagues have agreed that this ICC shall not accept the functional immunity, in this case, let's have the same point on the personal immunity, because currently everyone understands that without the three key officials, without their involvement, there wouldn't be any aggression against our country. So it sounds a bit strange that we can agree on excluding the functional immunity, but we still have questions about the personal immunity. making the personal immunity is a sort of a problem that couldn't be resolved. This challenge has already resolved that, and I think the legal community of our country has already negotiated that with the Western partners. We were also agreed that the only way to solve that through the establishment of a special tribunal. There's also several modalities for the establishment of such a tribunal. First, on the basis of the resolution of UN General Assembly, based on the agreement between the Ukraine and the UN, or the regional organization of such a body with the consent of the European Parliament of the European Union. There were some thoughts whether this option could be used, and it could, and I believe that this is the only way we could overcome this issue with the immunities once and for all. If that is something that shall be initiated by the General Assembly of the UN, then the issue of immunities won't be the case absolutely for the special tribunal hearings. As for the possibility, the true possibility, considering the fact that the aggressor state is a member of the Security Council, well, that's something different. Today we heard that there are alternative thoughts, and Andrei Smirnov has mentioned that there is an idea of creating such a tribunal on the basis of European country with a certain experience, but it's internationally recognized. I believe that we need to continue working as all the international lawyers, they clearly understand that if such a court or a tribunal would be established on the basis of the UN, that would solve a lot of matters that we face. Other models, which is hybrid models, I wouldn't be considering that model at all, because there's many principles regulating the court processes at the moment, more specifically the principles that the judge cannot be the judge of a case. If we are taking the hybrid system, then we know how complicated these cases are, and I believe that sooner or later my country will be left alone in the face of the aggressor, so it will result in a confrontation between the countries, so that would neutralize everything. Therefore, I would suggest to move away from such a model. Then the third model, the establishment of a tribunal as a multilateral agreement between Ukraine and the countries of the world, whether we could consider something like that, or it could be the agreement with the European countries, whether we could consider that such whether other countries may be joining such model in different form later on, well, that's also possible, but currently there is a point that a tribunal might be called international tribunal if this tribunal is established on the basis of two or more countries. If this tribunal will have a status of international, I believe not. So, if we'll stay with the third model as the major model for the establishment of a special tribunal, that is, the Ukraine will be joined by any willing countries, in this case, we will need to have as many countries as possible. We would need to engage them in any form, whether they recognized, not recognized, whether they join. There's many forms of recognizing this agreement. In this case, we can name the court international, and we can say that possibly this court might be able to overcome both the personal and functional immunity. We are, of course, welcoming the establishment of the International Center in Hague, which assists in gathering evidences of Russian aggression against Ukraine. But the legal community has certain concerns that if there will be a delay with the establishment of a special tribunal on holding the key dignitaries or leadership of the nation to accountability, we want to make sure that this platform would not be a platform with the sole purpose of creating evidences. That is why I support the point of our counterparts, both international and Ukrainian one, that first and foremost we have to accelerate the establishment of a special tribunal, as this is the only body that is capable of overcoming the immunity challenge. This is the challenge or the problem that we are considering for this conference. We thank Vitaliy for his thoughts and his comments, and what we have today during our panel discussions with different experts from the High Council of Justice, from the Office of the President of Ukraine. Well, it truly underlines that the topic of our conference, that's something that is shared by all the Ukrainian lawyers. This is a matter of concern to many of us, and we have to settle that. We have to search for the solution. So we believe that we need to support that point. And surely in the course of our debates on the immunity, we're not only talking about the functional immunity, we're talking also about the personal immunities, because this matter is directly related to three key dignitaries of any country. But it's important to understand that in certain cases you already have either a consensus or at least a common ground with your partners in order to continue with the development of the position and to work on matters where there's no common ground at this point yet. And for us, for all those working on the matter, the establishment of a special tribunal is one of the key matters for our portfolio. We are constantly working on that for a year and a half, and we shall be doing everything possible in order to accelerate the establishment of this judicial body as soon as possible. And surely the support of Ukrainian society and international partners is something that is crucially required. And we highly appreciate the establishment of International Center for the criminal prosecution of the crime of aggression against Ukraine. This is the first attempt to investigate the crime of aggression after the Second World War. Before this center was established, there were no international efforts to jointly investigate the crime of aggression. Now we have it. That's why we appreciate that. But still, as Vitaliy said, we have a common ground, common position that this center has to produce the materials that shall be used for criminal proceedings considered by the special tribunal. This is its purpose. And surely the investigation as it is couldn't be the end goal for the existence of this center. Now I'd like to pass the floor.
Our distinguished colleague from the United Kingdom, Sir Geoffrey Nice, a British legal professional, professor, expert who served as a prosecutor in the International Criminal Tribunal for the former Yugoslavia in the Slobodan Milosevic case. So, Sir Geoffrey, what are your comments and observations on the issue of personal and functional immunities, in particular in relation to the crime of aggression against Ukraine, and what are the instruments and tools to override them?
Thank you very much. Ambassador Anton, can you hear me?
Yes, quite well.
Thank you for inviting me. And I, of course, much regret not being able this time to be there in Ukraine. You ask me a technical legal question, and if I don't give you a technical legal answer, I hope you won't be too disappointed, but I'll do my best. But I must make it absolutely clear that I can't possibly improve on the academic discussion given by Frank Hofmeister and Carrie McDougall, neither of whose presentations I could have given and certainly not improved on. And I know we are going to hear further and interesting contribution about how to deal with immunity from Max Baryshnikov very soon. My conclusion is to some extent affected by the fact that after spending 7 years deep in the law of the International Criminal Tribunal for the former Yugoslavia and all other international law that related to it, I have since then become rather more involved in other processes, some of which are informal, all of which tell me that which was never really clear at the Yugoslav tribunal, which is that the only people ultimately who matter are the victims, the bereaved family members, as well as the state itself. But looking at the personal victims, ask oneself this question: what on earth would they say if a tribunal was established, was in a position or in an apparent position to deal with Putin and the other two, or any leading members of the army, or any subordinates carrying out wicked crimes, and they were to hear that there was an argument about immunity, why they should not be tried? They would regard the world order as of little value. Imagine yourself also being a trial judge or a composition of judges, where the only reason why Putin would not be tried is a detailed and academic argument on immunity. The judges would know they would be condemned, and rightly so. It seems to me, and I've said this before, but it's worth repeating, that Ukraine, having established itself on the highest moral ground, or indeed on moral peaks, is ultimately entitled to full international support for whichever kind of accountability process it decides upon. And it is quite clear to me at the moment that the chosen mechanism is an international tribunal, and therefore support must be given for that. And the arguments against immunity appear to me to be very powerful. But, and it's an important but, we have to look not just to the present, but to the future. And a number of considerations arise when we do, bearing in mind that the 100,000 cases constituting the 99.9% of cases to be dealt with in Ukraine will take decades to investigate and to try. I'll come back to the 0.1% of cases in a minute, but we need to have in mind as we look forward with ideas and concepts and problems of immunity on one side and realities on the other, that within those decades of investigations and trials, people will inevitably demand, whether we like it or not, and whether Ukraine likes it or not, that other methods of disposal may be appropriate in the interests of Ukraine as well as in the interests of the world as a whole. Dealing with the 0.1% of cases that Anton envisages not being tried within Ukraine, why not? I repeat again what I have argued from the beginning, that all accountability mechanisms concerning this war should be dealt with by Ukrainians, in Ukraine if at all possible, and in the Ukrainian and Russian languages, because trying anything in a foreign language diminishes the prospects of getting it absolutely right. And ask yourself the question whether the United States and Canada were to find themselves at war, or if England was to find itself at war with independent Scotland, would any of those four nations allow for the intervention of internationals in the adjudication process or accountability processes that would follow? Of course they wouldn't. Nor would they allow them to be managed in any other language but their own. And one has to be very, very careful about the hegemonic effect of the use of the English language. So these are some of the more general considerations about whether the preferred option of an international tribunal, which I am more than happy to support if that is what Ukraine wants, is actually completely the right answer. Now, I don't for 1 minute propose any of the informal mechanisms that I've been involved with, and I recognize that informal mechanisms of one kind or another, whether people's tribunals or truth commissions, are rarely, if ever, translatable into another environment. When we are looking at the question of immunity, we are looking at the question of immunity from process, not at the question of immunity from truth. It was very interesting for me to hear Anton refer to the need for the citizens of Russia to be held accountable by one method or another. And I think we're going to hear this afternoon of the value of the Nuremberg trial, which of course is of immense value because it was a trial of the leadership that happened very quickly and that endorsed absolutely the question of where moral right and moral wrong fell, determined by total defeat of Nazi Germany. But did that trial and the associated trials, did they have the effect that we would now require of them? No, they didn't. Because if you examine, on two grounds, because if you examine the attitude of those in Nazi Germany from the very top, close to Hitler, down to the bystanders at Kristallnacht, from the moment of the end of the war and until the end of all those people's lives, the vast majority were never prepared to acknowledge their real responsibility for what happened. And why is that important? The other reason Nuremberg's failings need to be confronted is this. After Nuremberg, was there deterrence? Vietnam happened. Many other wars happened. Do we know if any wars were defeated or rather stopped as a result of the Nuremberg trials? Hard to know. There's no evidence that deterrence worked. And so, as we consider Ukraine's choice, and it seems to me a very good choice, but I just don't know if it's the best, of an international tribunal. First, I would support it more wholeheartedly if it was run by Ukrainians for themselves, as in my view, it definitely should be. And if it were considered within an overall view that Ukraine has an opportunity to lead on, to look at what comes next. And here, Ukraine's interests and the interests of the rest of us do not necessarily absolutely coincide. Ukraine's interests, which will be delivered by an effective international tribunal, include retribution for the victims, and that's immensely important. And any of us who have not been victims cannot know how important. It's also to achieve financial recovery of money that may help in the rebuilding of Ukraine. Those are their interests, your interests, Ambassador. Our interests, now that nuclear war is the subject of recurring threat and reference, is to deter others as mad as Putin, who need to be stopped in what they're doing. And I come back to the ambassador's observation about the people of Russia and my observations about how Nuremberg did not succeed in changing the minds of the people of the country concerned. How can whatever Ukraine does now by accountability reveal in Russians themselves the recognition that they have been supporters of that which is criminal and evil? And how can we do something now in the accountability mechanisms that may be chosen by Ukraine to ensure that the next similarly disposed dictator, recognizing that he may not be able to take his people with him if and when he is called to account, may decide actually that it's too dangerous even to launch the exercise he has in mind. And then one last point about an international or internationalized, and here it doesn't matter, tribunal, before I close. If any and every tribunal or process that has international power within it will yield to the interests of the other major countries if and whenever they do not coincide with the interests of Ukraine. Do not be so foolish as to think that an international tribunal's overseas members will have the justice interests of Ukraine in mind if they do not coincide with theirs. The Yugoslav tribunal, arguably the very best evidence about Srebrenica, had an investigation that was simply stopped by the power of a major country because that country and possibly one or two others associated with it were concerned about reputational damage to them. And the truth of that has never emerged. And the same will happen if you ever allow internationals to have control over your justice process. So, in conclusion, if it is Ukraine's considered choice to have an international tribunal, we must support it, although I hope it will be comprised of Ukrainians taking international advice and support, but no more. When it comes to any question of immunity, I don't think anybody need be concerned in a war of this magnitude and wickedness that judges dealing with the issue will find against immunity as a defense to what has been done against your people. Thank you.
Thank you so much, Geoffrey, for your valuable remarks. It's important for us to hear the perspective from different scholars and practitioners and how do they feel these issues shall be solved. Of course, for us, Ukraine's governmental lawyers, our state's national interests are the most important ones. That's why we do our job. But here in this context, I do believe that our national interests fall together with the international interests of the international community when we talk about justice, accountability, and the future of international law, the future of international justice, the future of the crime of aggression, the future of the principle of non-use of force and non-threat of force. So I think that this is something what we can do together. And of course, we need international support in order to get the work done. Because it is obvious that when we talk about the crime of aggression, it should not really be the case of the only victim state approach. Yeah, so we need international assistance for that to show the international response to this issue. Наступне слово я хотів би надати.
Then I'd like to pass the floor to Ivan Horodyskyy. Right now he presents the Ukrainian Bar Association, the vice president. So for us it's really important the professional bar associations like Ukrainian Association or National Association of Polish Lawyers, for them to adopt resolutions and for them to support the special tribunal idea. So for them to provide this backup to governments, to parliaments, professional unions and associations support this movement. And we work with the Ukrainian Bar Association in a very constructive manner. So Ivan, from the standpoint of your entity and lawyers in general and associations, why it's important for us to have a special tribunal? Why? And what are your ideas regarding the immunities? Thank you so much, Anton. It's such a privilege to be a speaker. Well, being the last speaker, you can just say yes and agree to everything mentioned before, but I will complement a little bit just to draw the line under everything and summarize. I represent Ukrainian Bar Association. As a vice president, I can tell you since the very first day of the full-scale invasion, we support the Russian top leaders to be held accountable for it. We support this idea, and we have the American Bar Association supporting us. We were lobbying it actively. So we adopted a resolution to support that idea, establishing the special tribunal. When it comes to idea and the problem of functional immunities, Hannah Arendt once wrote that when we have war crimes, what is typical? A lot of blame is put on those who are absent or dead. So the full accountability, and you can't find truth, and you can't reach justice without the leaders of aggressive state to go to jail. One of the challenges we have sometimes are mentioned, or we heard different precautions and warnings, functional immunity and personal immunity for the top political and military leadership. This is the political dimension as well, because Russia, of course, will manipulate these immunities, trying to stick to its own deteriorated version and criticizing the world order and international law. But international law gives a chance to provide justified response to it. We already have a practice, starting from the Nuremberg trial, we have a lot of practice accumulated, that immunities cannot become a barrier to hold people liable for the most horrible crimes, including war crimes. So we already have a consensus that immunities are not like a big high wall or barrier when it comes to accountability for war crimes. And the leadership of states guilty for that can be held accountable by international courts acting on behalf of the international community. We heard these statements. I will not repeat, I will not go deep. The decision of ICC on al-Bashir case, and also the decision, the Erstborn case, and a bunch of others. So it all tells us that certain consensus is there.
But still, we can't say that those decisions, we can't take those decisions for granted. That the main precondition that guarantees the full identification of the immunity situation with regards to the Russian officials. This is already mentioned by our previous speaker. There has to be a substantial international support to this idea with regards to holding accountability for the key Russian officials. First, we need to make sure that this future tribunal that Ukraine is willing to create, first we need to make sure that this body will have an international status. This is the consistent position of Ukraine. This is a true position, but there's no clear definition, and we're still lacking some support from countries that would say that this body is international. The Abu Suji and other lawyers, they say that calling the tribunal international doesn't mean that the tribunal is in fact international, and the involvement of 2, 3, or even 15 states does not guarantee that from the standpoint of international law that would be an international body. Therefore, in order to confirm that the future tribunal acts on behalf of the international community, we need to ensure the maximum involvement of other states for that establishment. It could be done either under the aegis of EC, UN, or international agreements. This future institution would have to gain support from our allies as well as the global south countries and other countries. There has to be substantiation to its legitimization as well as jurisdiction in other. Argument that we sometimes can hear from our partners is that many people have a very cautious approach to functional immunity, that it will have derogation for that. Then there could be derogation from the immunity for the key positions of our own countries. We have to say that the chief idea is not that the international criminals shouldn't be using the functional or personal immunity, so it would be absurd to say that nationality or citizenship might have additional arguments for these or that parties to use the immunity. Serhiy Plokhy, the historian, in his book Yalta, he said that during the Yalta conference, it was Stalin who said that there has to be a court against the German Nazis, but he wasn't trying to have a supremacy of the law. He remembered about the political processes over the opponents in 1920s and 1930s that were mentioned by the propaganda. Still, the Nuremberg process has become one of the most convincing manifestations of justice and international law. Now, there is a need to prove the effectiveness of the joint international efforts to punish the perpetrators, and the functional immunities cannot serve as an obstacle. The idea of functional immunity is to promote the use of international law and support international relations, and not to serve as protection against punishment for committing the grave crimes. And the Ukrainian government and the team working on the establishment of a special tribunal and holding perpetrators accountable, still they have to take a long way but it's achievable, and we shouldn't take certain facts or decisions as granted. We still don't have assurance that they would be approved at a proper level. There's still a lot of work to be done, but it is the main prerequisite for the imminent justice for Ukraine and for the Ukrainians. Thank you, Ivan. We truly appreciate the Association of Lawyers of Ukraine and the support of International Bar Association and many other bar associations, and we shall continue working during our joint events and during campaigns in order to make this complicated work possible in order to establish a special tribunal. And I believe that all of us in the audience, in this room, as well as listening to us online, if that's a tribunal could be established easily, we would have done it already. It's a very complicated work, but I can assure you that the team working on the matter will do everything possible in order to have a result. Whenever I start thinking about the complexity, I always come to a point that Raphael Lemkin and Gershon Compact had it all in a much more difficult circumstance in 1940, because we have already the international law that they had to establish in their due time, so we surely have all of that. Now I'd like to pass the floor to Maxim Baryshnikov, the partner, BKB Attorneys at Law, and he's joining us online. So Maxim, please, your thoughts on the immunities.
Organizers for kindly giving a chance for my participation in today's conference. And as a Ukrainian lawyer and co-founder of Salikhov initiative group Kick Russia Out of the UN, let me speak in Ukrainian. Дякую за увагу і
So, thank you for the intention. I believe that it's not a coincidence that today's conference is taking place on the eve of a very important event, which is anniversary of the ratification of the UN Charter. As we know, that took place on the 22nd of August, 1945. And it is not coincidence that the day when the ratification papers were provided to the US State Department is currently marked on the 24th, and that was the last ratification that was necessary to enact the UN Charter. Because we have to say that in the beginning of the active phase of the aggression, Ukraine faced the question was holding accountable for Russia, the main perpetrators of the aggression, largest aggression in the 21st century, and everything that is taking place with the use of the medieval tools. In fact, Ukraine has faced with a choice. She could either go to the ICC, but the counterpart has already explained the limitations of Chapter 8 of the Roman Statute that Ukraine has not completely ratified for unknown reasons to me. On the other hand, there is an ability to establish a special tribunal based on the decision of the UN Security Council or with the support of the UN Security Council. The third possibility is the establishment of the ad hoc tribunal. I did not participate in taking the decision. As a lawyer, I don't fully share the views on what choice was made, but talking on the matters of the protection for the heads of state and government, the possibility for holding them accountable, we should take into consideration the court practice as well as the procedural norms for the court of the tribunal. Since we are talking about the ad hoc tribunal, it would be hard for us to say which exactly norms which judges or international arbiters will be carrying. They had a wonderful description of the possibilities provided by the international law. Jeffrey Nice, who is far more patriot of Ukraine than some of the other laws that I know, because we, the Ukrainians, still have some sort of issues on the international platform. We still say that the prophecies can be made only by some other countries, while Jeffrey Nice supports the idea of using the national tools for bringing to justice or holding accountable and identifying the sentences as well as the compensation. Because when we're talking about the special tribunal, there's two cases. First is holding accountability for the crime committed, as well as the identification of the fair compensation for those affected as the result of the crime. And in our case, that would be millions of Ukrainians. For many years, the initiative group of Get Russia Away from UN says that we need to stop the unjustifiable participation of Russia in the UN and in the Security Council of UN, since there's no legal grounds to support this, and the experts of the international law are fully aware of that. And our ideas are so much universal on the matter that the issues of establishment of an ad hoc committee tribunal are not working. Because why are we referring to the establishment of an ad hoc tribunal? Because for certain reasons we can't get reference from the UN Security Council for the ICC to start the comprehensive investigation and prosecution of the perpetrators of the crime of aggression. Why aren't we referring to the international tribunals that took place earlier, and they were established with the support or in accordance to the decision of the UN Security Council? Because we clearly understand that Russian Federation will use a veto right. Should we consider the matter of holding accountability to the other heads of states and government? We've already heard about the tribunals of Rwanda, Kosovo, former Republic of Yugoslavia, and others. In many cases, they were either established and operated under the decisions of the UN Security Council, which is something that is impossible for Ukraine, or they were taking place under conditions that the country that was culpable, or the leadership that was culpable, they agreed voluntarily to give away some of their officials to stand trial. We understand that this requires a complete and utter change of the political elite and the situation in a certain country. Therefore, should we apply for the tools that are outside of the support of the UN Security Council, which is the only body that, under the UN Charter, whose authorities were ratified in 1945, then we take a very kind of a dangerous road. We don't know the consequences. One of the statements mentioned US and other partners. Truly, Ukraine is not in the vacuum. This is something that is happening, everything's happening together with our partners, and our partners, they have the majority in the UN Security Council, and they're not really interested in the establishment of a special tribunal, because who knows, maybe later on they would be considering their own cases. For example, there was a military operation in Iraq, and Ukraine, together with its partners, participated in this operation. There was no decision of the UN Security Council on that. That is, therefore, there's no chances that somewhere in future there would be a special tribunal in that case. Now, do we have 100% support from our colleagues from other countries, members of the UN Security Council? It's hard to say. This is why I've started my briefing with referring to an event that took place many years ago, that still it has an impact on the situation in Ukraine as well as the situation around Ukraine. Now, should we refer to the current legislation of Ukraine, we have to point that there's only several decisions. First is the statement of the Verkhovna Rada of Ukraine of the 25th of February 2014, then a statement or an application of the Verkhovna Rada of Ukraine on recognizing the jurisdiction of the ICC. Then we have to mention another statement as of 14/04/2022 by the Verkhovna Rada of Ukraine on the genocide of Russia in Ukraine, as well as the application of the Verkhovna Rada of Ukraine as of the 7th of November to the UN, to the General Assembly, to the Parliamentary Assembly on the establishment of a special tribunal on the crime of aggression against Ukraine. Unfortunately, we're still not a fully fledged member to the process, which is taking place in accordance to the Roman Statute of the ICC, but we can see that this process gave the only positive result out of everything else. There's already an arrest warrant for Putin on a very specific case. The other actions did not result in any practical results. Therefore, the initiative group Get Russia Away from UN calls upon the others to use the available resources and take the shortest and the most understandable road for the Ukrainian lawyers. That is the position with regards to the ICC. For that, we need to implement one of the scenarios that the members of the initiative working group has developed. These are the most prominent experts of international law in the world. This is the path leading to the termination of the unjustifiable participation of Russia in the UN operation. This will open the possibility for transferring the case of aggression to the ICC for consideration of the genocide case and for considering the case of identifying the compensation. Could be at the level of national and international level. It could be done through the mechanisms that are already available, because as part of ad hoc tribunal, the ICC has its own secretariat, regulation, procedural norms, and these norms have been tested many times on certain cases, or it could be the establishment of a special tribunal under the aegis of the UN Security Council, which already has a number of court practices and case laws that were already mentioned by the colleagues already mentioned before. And in this case, we would be able to use the experience that was already gained or already developed by many of the international lawyers, and we shall not be inventing the bicycle once again. Therefore, we are suggesting to take the short road, to take the simplest and smartest way without establishment of new artificial bodies, but by using the mechanisms that were already used in the international relations and that are fully compatible, according to the majority of the experts, that are fully in line with the norms of the international law. Therefore, we have to point the following. In the very beginning of the new phase of military actions, Ukraine has submitted a claim to the International Court of UN. What's the situation with the application?
Excuse me, Maxim, we're about to finish the panel. Yes, we cannot discuss all our tools, so I offer the participants to think that the choice could be made with certain limitations, let's say. Okay? Thank you for attention. Thank you so much. Thank you. Thank you. Thank you, Maxim. It's so important to get all the voices heard. And in the hall, we have colleagues working at MFA, the UN International Court on Genocide. Yes, and soon you'll hear about that case. Soon you will. Yeah, even for international justice, if we had this best solution, the fastest one, we would have already taken that. If we speak of the UNSC, the majority of 15 members, they have to vote for a certain thing. And a veto right is a veto right when we have 9 members of the UN Security Council, when they say yes, when they vote for. So we are convinced that if we just put aside this discussion, yeah, the participation of Russia, the membership of Russia in UNSC and in the UN in general. So we do not invent a bicycle here. We're not trying to put a 5th tire to the car, but we are trying to create an important justice mechanism, special tribunal on aggression, crime against Ukraine. In particular, we understand what kind of support we get, and you also can hear that. So to me, it seems that the vector of our movement is picked. It's a proper vector. It's a correct one. So we will continue working with it. The UN International Court, you will hear about it. We guarantee. So just to finish the discussion, I'd like to express my gratitude to all our wonderful panelists and to all our wonderful participants for truly valuable ideas and personal considerations on why do we need the mechanism for this crime of aggression against Ukraine. It's so important that we have this wonderful support from international community and from Ukrainian society. You know, today a lot is mentioned about the unity and how to support and maintain the unity. I'm pretty sure that when it comes to international accountability and personal criminal liability for the most serious crimes, this unity is important. I really encourage you all to think that each of us, at our own places, what can we do to help us bring justice to our country faster? The first idea is really simple, so you can use the QR code and sign that document that we mentioned in the beginning. So this may be the first, or for someone else, the first contribution to the support of Special Tribunal idea and the accountability for crime of aggression against Ukraine. We have colleagues here. Together with them, we took part in the first conference on May 6th, 2022 in Vilnius in Lithuania. And that summary became an important step for us to get international support regarding special tribunal will continue working. I'm pretty sure we'll find the answers to all questions, and we will definitely say that the crime of aggression against Ukraine shall be subject to prosecution. So we'll do everything we can for it. Thank you for your attention.
Дякуємо ще раз, пане Антоне, і вам, і ваші ці оплески.
Thank you so much. This applause is for you. Thank you for moderation. I'm grateful to all the speakers.
That joined us here and online. Thank you very much. Дякуємо ще раз за цю панельну дискусію.
Thank you for the panel discussion. So, friends, this is 2 p.m. In an hour, we want to get you back after lunch, so enjoy.